Good morning, everyone. I want to thank you for spending some time with us today. We're actually going to talk about the ETF legal landscape and have our panelists give their thoughts and opinions on pending and recent regulations and their impact on ETFs. As a brief introduction, my name's Mike Prendergast. I'm an ETF product head at Ultimus Fund Solutions, where we offer full fund administration services for registered products. We also sponsor 10 series trust, ETF trusts for both mutual funds and ETFs. I'd like to introduce our panelists, briefly have them each introduce themselves, and then we'll get into the topics.
Thanks, Mike. I'm Jeremy Senderowitz. I am a shareholder in the New York office of the firm of Vedder Price. I've been at Vedder for about 3 years, and I've worked with ETFs for about 20 years.
Hi, my name is Aisha Hunt. I've been an asset management attorney for going on 25 years. I'm the principal of Kelly Hunt, an asset management law firm. I also recently launched a sister company, Next Gen Fund Consulting, where we're focused on ETF product development consulting with a particular emphasis on preparing for ETF share class relief.
Hi, I'm Morrison Warren. I'm a partner at Chapman & Cutler. I chair our investment management practice. Our practice is heavily focused in the ETF space and crypto.
I'm Stephen Carson, the head of the asset management practice at A&L Goodbody, which is a leading Irish law firm. In that role, we advise issuers and asset managers on establishing Irish ETFs. I hope to give a European ETF perspective today. I'll be doing that through the prism of Irish ETFs, because Irish ETFs represent over 70% of all ETFs established in Europe.
So obviously there's been a lot of conversation around Bitcoin and crypto. So I think we just start that off, and what's next? Where are we with the next version or the next phase of crypto?
Well, it's funny you should say that. I was just checking my phone to see if the answer to that had changed in the last few minutes. It doesn't appear to have, fortunately, but things have changed a lot in the last 48 hours. So just to refresh a little bit, in January, following a defeat in court and the regulatory deadlines that approached at that time, the SEC finally, after almost a decade, approved spot Bitcoin ETFs. Soon after the SEC lost in court in such fashion that it became likely that they were going to be forced to approve the Bitcoin ETFs, a number of sponsors also filed for spot Ether ETFs. After the Bitcoin ETFs launched, a lot of people, myself included, thought that the eventual launch of the spot SEC approval and the launch of the spot Ether ETFs was basically a fait accompli. But for the last several months, the SEC has maintained almost consistent radio silence, not engaging with either the exchanges that filed the rule changes where the regulatory deadlines are approaching, or the issuers with their registration statements that were filed to launch the products. So until about 48 hours ago, the wide consensus within the industry and among the participants, even among the registrants and exchanges themselves, was that the SEC was going to reject these Ether ETFs. But just about 48 hours ago, the SEC essentially pivoted on a dime and reached out to the exchanges and the sponsors, saying, all right, if you make these changes, most notably to remove any reference to staking, then we will approve these 19B4 rule changes that will allow the products to list. So since then, there's been a lot of scrambling and a lot of public filings that have been made, but it does appear that the SEC is in fact going to approve the Ether ETFs. The exact timing is a bit unclear, though it might be at the end of this week where they approve the 19B4 rule change filings, which, just by way of background, have a defined time frame that's set out in the statute, as opposed to registration statements where effectively they don't have a defined time frame for the SEC to declare them effective in most circumstances. So the SEC is essentially, the SEC had this deadline that's been approaching for several months, but like a student procrastinating on homework, the SEC made its decision at the very last minute, but everyone is happy within the industry that it appears they are indeed going to approve these.
Yeah, I would add, I think this is going to usher in a new generation of digital asset ETFs. I mean, we also have in the pipeline, 2x levered Ether ETFs that also will be waiting, the SEC's assessment of their filings. And so I think we're really looking at being on the cusp of this. I don't know, Morrison, what are your thoughts?
I absolutely agree. This is a circumstance where the SEC is realizing they can't stop products because they don't like them or they assume there's too much risk. And so as a result, these products will go quickly. There will be derivative products that will use these as underlying assets. And so I think we're really going to just see more access. And I think it makes a ton of sense. Ether's obviously available to investors now, but in a less regulated, less controlled, less protected way. So why not make it available in sort of the most regulated way, having it list on an exchange? So I think this is the future. Hopefully they orchestrate this process the same as they did with Bitcoin. The SEC did not want to benefit one sponsor versus the other, and so they gated the Bitcoin approvals at the same time, effectively, so all 11 went at once. Here with Ether, there are filers at different levels. I think the 19B4s are all going to be approved to the extent they're ready. The SEC will have a harder time controlling all the S1 filings. S1 filings are the registration statements that are used for 33 Act products, non-40 Act products you're used to with ETFs, N1As, similar, but under a different regulatory regime. They have to be declared effective. However, Grayscale has an existing product that is an Ether product that is currently been through the registration process or has existed long enough so that I believe it can go automatically effective. So the SEC is going to have to wrestle with how they're going to gate all of these filers when Grayscale may be in a better position.
Thanks. From a European perspective, what's their view of crypto, and where are they in that?
As a European mutual fund lawyer, it absolutely astonishes me that trade bodies or issuers will sue or take on the SEC in this way. We're obviously too mild-mannered in Europe, and as a result, we don't have any real ETFs or exchange-traded funds providing direct or indirect crypto exposure. But we have had ETNs providing physical spot derivative exposure to cryptocurrencies for a long time. And they can be distributed to retail and professional investors across most European member states. That has tended to satisfy the market, but as I'll probably touch on a few times today, what happens in the US ETF market typically flows through to Europe within the next year or two. And so with the advent of Bitcoin ETFs in the US, a lot of our clients and issuers have been asking, why can't we do this in a fund wrapper in Europe? So one of the challenges is that ETFs in Europe are structured as UCITS mutual funds with an ETF infrastructure in place. UCITS are designed for consumption by retail investors across the European Union, so they have quite strict eligible assets rules. As it happens, the European super regulator, ESMA, is currently doing a review of eligible assets for UCITS to include UCITS ETFs. And as part of that review, they will consider, and have issued a call for evidence to the market, they'll consider whether direct or indirect crypto or digital asset exposure is appropriate for retail investors. To the extent that there are any changes coming out of that, it will take 2 or 3 years to come through the legislative process. I personally wouldn't be overly optimistic that we'll get to a place where you can have a single cryptocurrency exposure through a UCITS ETF. But in the meantime, we do have spot, Bitcoin and Ethereum ETNs that are largely satisfying the market demand.
Great. And then sort of brings us to the next point. We're looking at different paths of entry for folks to come into the ETF marketplace. Obviously, we've seen tremendous growth. We see people basically filing under Rule 6011, which is a fairly quick and simple process. We're seeing mutual fund ETF conversions. But now we have at least a dozen or so sponsors that have filed for adding an ETF share class to their existing mutual funds. And obviously, if and when this gets approved, it's going to have a dramatic impact on the industry. What if a sponsor is considering this? What is the process to file or to get exemptive relief as it relates, and why is exemptive relief needed?
Sure. ETFs were not a creature of the statute. So ETFs were a creature of exemptive relief. So they existed, and individual firms got relief from some of the limitations in the Investment Company Act to list and trade ETFs. Rule 6011 was put into place that took away the need for that exemptive relief and created an opening to allow ETFs to be created by anyone who satisfies the conditions of the rule. The rule does not allow for multi-class circumstance, and so therefore you have to apply for exemptive relief. Exemptive relief was applied for and received back in 2002 by Vanguard, and they use a multi-class structure where ETFs are wedded to mutual funds, and they use it extensively. I think there are over $1 trillion in that system, 70 plus funds. And they had a patent on that process, and that patent had rolled off at some point last year. And quite a few folks were thinking this might be my solution to a problem that exists in terms of sort of branching into the ETF space from a natural mutual fund business. One of our clients had asked the SEC, and this was a couple years ago, knowing that the patent was to roll off, and the SEC had said, no, we don't want this, we don't like it for a range of reasons that we'll talk about here. But ultimately, the idea was, well, let's make the SEC consider this, right? Because there is enough desire and demand to move forward, and so eventually they filed, and now I think there are 12 or 13 that have filed. And SIBO also recently filed something. And I think this momentum is going to be necessary to drive the SEC to realize that this is important enough to do something about it.
Yeah, I think the momentum is going to ramp up quite a bit. I mean, we're talking about a $32 trillion industry of mutual funds and ETFs. About a third of those assets are in ETFs. And when we obtain ETF share class relief, we'll be moving toward a world where most fund managers, most multi-billion, multi-trillion dollar asset managers that manage mutual funds and ETFs will have to consider whether or not they want to apply for a mutual fund or ETF share class to be added to their fund family. So if you're an ETF family, why would you bypass the opportunity to add an ETF, a mutual fund share class to access 401k distribution channels? And if you're a mutual fund family, if you have taxable shareholder base primarily, why would you pass on adding an ETF share class to take advantage of the tax efficiencies? And even if you are a mutual fund that has a number of tax-exempt shareholders through 401k plans, why would you leave an ETF share class on the table for scale, right? So there are so many motivators with respect to why large mutual fund managers will be looking at ETF share class relief and why ETF issuers will be looking at ETF share class relief to add a mutual fund share class. And I think it's worth noting that we're all aware of the various trends with respect to how managers, as you mentioned, Michael, are moving into the ETF space. They've been moving into the ETF space through mutual fund to ETF conversions, clones or mimics, where they mimic mutual fund strategy and ETF wrapper. Those pathways would essentially be eliminated when we obtain ETF share class relief. So while I know it was quite a road to obtain, basically to get approval for spot Bitcoin ETFs, we're looking at, I think, a much shorter road relative to the spot Bitcoin ETF regulatory path in obtaining ETF share class relief. So I think it's really important that the entire industry really focus on what it means for $32 trillion of assets to start moving toward what will be more of a hybrid fund ecosystem, not just where we have mutual funds or ETFs, but where we truly have funds that have both mutual funds and ETF share classes.
Given that, what are some of the concerns the SEC may have, or what are some issues that need to be addressed? I mean, what's the temperature at the SEC? What roadblocks might be they putting up or to sort of delay this process?
Yeah, the first thing the staff is indicated is that with swing pricing pending, that it's really hard to understand how an ETF share class and a mutual fund share class would function in the same environment. There is some skepticism that swing pricing will actually come to fruition, and we had viewed that as being, just not being willing to sort of face the issue, because if it comes, Vanguard will cope with it, and anyone else will if you have to. Beyond that, the staff was worried that perhaps there would be a negative tax impact on ETF holders, perhaps there'd be extra cash drag on ETF holders, perhaps there would be an unfair distribution of costs or allocation of liabilities associated with all these things. And our sense is, well, those are issues to be worked through, and disclosure solves for a lot. And there is a board involved, and a board can decide as to whether it's appropriate for this fund to have that structure. And so we think they're mitigators for the things that the SEC has raised, and they should just give us a chance to sort of fight through the issues. They are providing comments, so they're providing comment letters even though they're saying it's not ripe. And they expect you to respond, or they withdraw your application, so you have to respond within 120 days. Our hope is there are more filers and more responses, and this just sort of drives this forward, just to create just another tool in the toolbox. Like, if maybe you want to do a conversion and you don't need this, fine, but maybe this is a better way for you to bring the same strategy to another market. So we're hopeful that additional pressure, and then perhaps a new administration would be more open to this innovation.
Yeah, that's all right. And I think the recent CBOE filing that you mentioned also feeds into this. The CBOE, just to be clear, recently filed a rule change requesting that would allow them to list ETF share classes of mutual funds on the exchange. It's unclear whether or not a rule change would technically be necessary for them to list these ETF share classes on the exchange. I think fundamentally this is about, that filing was about both further demonstrating broad support within the industry for at least the ability to use this structure, and also to help put public pressure on the SEC. Yeah, and I think Marcin's absolutely right. I think there's broad skepticism within the industry that that the concerns the SEC has raised are ones that are too difficult to solve by a combination of disclosure and policies and procedures for managing conflicts of interest that advisors have to navigate every day of the week. So I think, and we literally have $1 trillion proof of concept that the structure can work to the satisfaction of investors. So I think I'm also optimistic that sooner rather than later, the SEC will feel enough pressure to move and allow the structure in one form or another.
I would add, I think that from, our firm's vantage point, we're a little bit more bullish. We have the privilege of working with FM Investments and RBB Fund on their filing for ETF share class relief. FM Investments was the first ETF issuer to add or propose adding mutual fund share class to their ETF family, the U.S. benchmark series, in particular T-bill, which is a single issue treasury ETF and holds a 3-month T-bill. And I think the inherent nature of that strategy, addresses a number of SEC concerns, and so it is an esoteric set of facts and circumstances. And as the SEC, has laid out in the adopting release to Rule 6011, the ETF rule, it really is a facts and circumstances driven analysis that the SEC is conducting. We made the third filing after Vanguard's patent expired, and again, the first ETF issuer to ask to add a mutual fund share class. And so we've been experiencing the SEC being very engaged with us, and we're very hopeful that the SEC will grant narrow relief in this space that will, create inroads for, broader relief to be granted. I mean, when you think about Fidelity and Morgan Stanley that filed on the heels of our filing, they took a different approach. To Jeremy's point, when, I think the earlier filings, Perpetual, which that filing was recently withdrawn, and Dimensional, they took an approach of kind of a kitchen sink asking the SEC for relief for the entire fund family. When we filed, we set a standard, I think, of narrowing relief to really focus on the attributes of the specific funds and with the U.S. benchmark series. And I think the applicants that followed us, like Fidelity and Morgan Stanley, and all of the filings since then have taken the approach of really putting the purview, proposing that the purview of selecting which funds are appropriate to grant relief or to add ETF share classes be within the purview of fund boards. And so I do think that that's a modification that makes the road a little easier, in terms of having larger issuers really bring tailwinds to obtaining broader relief. And I would also add to Jeremy's point, I think that the grayscale litigation really has been a way to, it's really created an easier path in terms of the SEC's assessment of this regulatory initiative. Grayscale prevailed by making the case that essentially the SEC had arbitrarily withheld approval of rule amendments to permit spot Bitcoin ETFs since they were already in existence, Bitcoin future ETFs. And we, in this case, have a much stronger case because we have the Vanguard model out there operating, and I think certainly in discussions with the staff, to the extent there's reservation with granting broader relief, that topic will certainly come up for discussion. And so we're certainly more bullish because I think we're making a lot more progress by working with facts and circumstances with the U.S. benchmark series and in particular T-bill.
Yeah. And I will throw out there is, I'll put my ops hat on, there is an operational component of being able to service these when we do get sort of better guidance on what needs to be done, if there's going to be any separation of sort of class activity. So it's, but that's a future panel discussion for another day. Looking from a European perspective, I mean, what's their view on share classes?
Yeah, and I think we have been quite fascinated by the Vanguard patent and how that was a barrier to others using that facility. When you look at Ireland, it has been possible to do ETF and non-ETF classes in the same product since as far back as 2017. But actually, in the years that followed that, we didn't really see very many managers use that facility and add listed or unlisted classes to a product. But actually, as I mentioned earlier on, once the trend or the focus in the US market turned to this in advance of the Vanguard patent roll-off, then managers and issuers in Europe started to look at it as well. And when you combine that with the fact that, like in the US, European traditional mutual fund managers are now actively trying to work out how do we implement an ETF strategy or how do we convert our existing mutual funds to ETFs, one of the options is to consider launching ETF share classes. And I think it's worth kind of noting in contrast to the approach in the US, in Ireland you don't need exemptive relief, but rather it's a disclosure issue. So you update your prospectus to disclose how the two different types of share classes work. It's not a separate authorization. So from a regulatory perspective, it's quite straightforward. There's probably just two cautionary points around that. Many of you will be aware that the reason Ireland is the top domicile for ETFs in Europe is because mutual funds which are regularly traded on exchange can access the US-Irish double tax treaty, which provides a much lower withholding tax rate on US source dividends. Now, if you are an existing mutual or ETF and you have a US equity allocation and you're relying on that double tax treaty access, you need to be careful if you're adding a mutual fund or an unlisted share class that you don't fall below the regularly traded threshold. That's not to say you can't add an unlisted share class and continue to access the benefits, but it's just something that needs to be factored into the structuring and the compliance monitoring. The other point, and it's a fairly minor point perhaps, but if you have an existing mutual fund and you add an ETF share class to it, then you have to change the entire fund name to include the reference UCITS ETF. That doesn't sound like a big deal, but for some large mutual fund managers who have flagship unlisted funds who like the idea of adding an ETF share class, that requirement to change the name of the fund is a blocker to that for some managers. But we're seeing this as a big part of the conversation at the moment, and I think we're definitely going to see it as part of the conversion toolkit over the next year or two.
Okay. Switching gears a little bit, just looking at sort of recent changes, regulatory changes or rule changes, and what's sort of what do we think is going to happen, say, between now and the end of the year? So, Aisha, how's the potential or the temperature at the SEC, given potential change in administration or staffing within the SEC, and how has the grayscale ruling impacted things?
I mean, I think the temperature has gone down a bit. I mean, last week we heard SEC Chairman Gensler talk about really revisiting the regulatory agenda in the remainder of the term of the administration and really reopening and potentially modifying some proposed rulemaking, including the proposed amendments to the custody rule, the AI and data analytics rule, as well as swing pricing and getting input from industry participants, in particular the banking industry, that have raised a number of concerns, or ETF issuers that manage bank loan funds. And so I think there has been a pivot that we've seen in the latter part of the term as we approach potential transition of an administration. And I think that temperature being brought down is a big relief to the industry. I think there's been, frustration and concern that this administration, led by Gensler, has really taken a prudential regulatory approach that hasn't always felt like it's been a fit for the institutional asset management industry. And we think that, there's going to be hopefully more of a normalization of the really rulemaking agenda as we move forward.
I think we're at a really interesting time, especially in the ETF space. The SEC did a couple things to streamline what happens. One, they created Rule 6011. So now you can do a whole range of ETFs without approval. Two, they modified the rules regarding listing. So you can list on an exchange, essentially, if you qualify to be an ETF, a 6011 ETF. Three, they modified the derivatives rule. And so the derivatives process is totally flipped over. It has now a value at risk determination to determine whether you are able to hold derivatives. And instead of cover, which was you had to have liquid assets covering obligations in the prior world. And so it's led to this explosion of funds. And with it, people are constantly challenging the SEC with new ideas. I think the grayscale case, where folks realize if you think it's unfair, perhaps fight it, is now the pervasive attitude. In the past, when we'd file registration statements, if the SEC said no or stop, we would stop, right? Because we feared there would be retribution later in the future, or perhaps just something would be wrong. Now the idea is you get to get in one backdrop or context, you get to go automatically effective if you have an effective registration statement. It's just the passage of time. You take comments, you respond to the comments, then go effective. So the power is in the hands of the issuers, and the SEC knows it, and people are willing to fight. So you will see more aggressive pushing to get products across the line that in the past folks would have just stopped when the SEC had indicated they didn't like it.
Given that backdrop, increase in derivatives, and obviously use of 18F4, what are some things that an investment manager needs to think about to be in compliance with that rule? Because we've seen a proliferation of those products, proliferation of the complexity of those products. But what are some considerations an investment manager needs to know that they have to be compliant?
Sure. Yeah, the 18F4 regime requires the manager to implement a derivatives risk management program, and it requires it to be adopted by the fund board. This program has a number of key components. It has to, first, as Marcin mentioned, has to establish a means for measuring the value, a way for measuring the value at risk that's at use in the fund's derivatives at any given time. The value at risk, value at risk is measured by a couple of different standards that you have the ability to choose between. Either a relative standard was compared to either the fund's portfolio or a benchmark index, or an absolute amount, which is much lower. It also requires the program to have processes for stress testing the fund's exposures, for back testing its exposures, and to implement processes for reporting any issues that come up. It also requires the appointment of a derivatives risk manager who must have an independent line to the fund's board. So these are all, this essentially formalizes in addition to replacing the previous farrago of interpretations and ad hoc positions taken by the SEC staff over a period of decades, not all of which were consistent with one another. This program formalizes the factors that a manager has to implement, and it just requires a fair amount of infrastructure. So these are all issues that if a manager wants to offer ETFs that utilize derivatives-based strategies that are in compliant with 18F4, it requires this infrastructure to be put in place. We've already seen, just in the few years that the rule has been in effect, we've seen it has a real effect on the ETF industry. The first one being right when the rule went into effect, and when the previous SEC, one of its last items was to amend Rule 6C11 to allow leveraged and inverse ETFs, which previously had been excluded from the rule, to be offered under the rule as long as the ETF rule, as long as they also comply with the 18F4 regime. So that had the effect of opening up the leverage and inverse ETFs to new applicants to new registrants from the as opposed to the few registrants that had the original exemptive relief to offer those products and had been frozen in place for over a decade. The second item is that the adoption of 18F4 has essentially cleared the way for the use of leverage and inverse single stock ETFs. That have been launched in the last couple of years. There's been a lot of attention paid to some of those high-profile products, and they track the Teslas of the world, which attract a lot of short attention. Basically, those products wouldn't have been feasible in a pre-18F4 regime, but they actually do fit into the new 18F4 regime by use of being able to essentially utilize their underlying stock, the reference stock as the benchmark.
Thank you. The a couple other things that have sort of happened recently, Aisha, the impact on ESG, the names rule. I mean, what are you seeing there as even for new filings, and what impact on existing clients?
I mean, I think ultimately product initiatives are still moving forward thematically in the same course. It's just, I think, important to work very closely with your 40 Act counsel to make sure that you're thinking about your fund name. I mean, often, you have clients that come to you and they have their heart set on a fund name, right? Heart set on a ticker. They've often already acquired the ticker. And so I think one thing that the biggest takeaway, I think, for this room when you're thinking about new products is even some of the most seasoned ETF industry executives are accustomed to the prior names rule requirements, and it's really important, especially for ESG-themed ETFs, that you're really working closely with counsel and you understand the contours of the amendments to the name rule and how it impacts your product development initiatives at the forefront of the initiative.
There's also an interesting sidebar with respect to index funds, of which still make up the majority of ETFs, and that the names rule, and that there can, depending on how closely the fund name matches the name of the index, which is often very close but not 100%, there can be a legitimate question about whether the fund needs a separate 80% test for investment terms within the name, or if it's sufficient to have an 80% test to invest in components of the index.
It's just interesting from a European perspective, because we've had our sustainable finance disclosure regime for a few years now. That's currently under review, but it never introduced a minimum ESG criteria. But just last week, we had the European version of the names guidelines issue, and that's the first introduction of minimum ESG criteria, but of course linked to the words sustainability terms you use in the name of your product. But one of the frustrations for the ETF industry in Europe is that it didn't carve out where your fund is named after your index, as you just mentioned, Jeremy, and so we're likely to see decoupling between fund name and index names to a greater extent, I think.
Yeah, the staff is amazingly focused on the names. So every comment letter you get, there's a name reference. Recently, we've been hearing about tickers and trying to enforce the same rules on tickers. Our clients have aggressively pushed back because there's no no regime for tickers, in terms of being misleading. But it just gives you a sense that the staff is worried that someone's going to make a determination off of just the name or the ticker. So therefore, they want to make sure the name isn't misleading. And so this is sort of going to be an ongoing determination, what's in or what's out. But it will affect your product development.
So real quick, we just have a few minutes left. Any pending, I'll say, rule changes or things the SEC are looking at that's worth mentioning, whether it be the liquidity rule, swing pricing, or the oversight of the advisors?
Yeah, sure. There are a few items. First, swing pricing is still like the 800-pound gorilla, so to speak, which is that because if the swing pricing rule is adopted, it would have enormous and, in the opinion of mostly negative impact on the mutual fund industry. It could have, if adopted, have assorted more positive consequences from the industry for the ETF industry, because many managers have said then they will go all out converting their mutual funds to ETFs so as to not have to deal with swing pricing. That's not exactly the way that the ETF industry necessarily envisioned its growth, but the fact is that, at least in recent months, the SEC has been sending signals that that they're not actually going to be moving forward, at least anytime soon, with the swing pricing regime, at least as contemplated. With respect to liquidity rule, let's deal with that first. The SEC about a year or more, or 18 months ago, proposed amendments to the liquidity rule governing open-end funds. One of which would have explicitly classified loans as being in a less liquid bucket. Because it's always been a somewhat controversial issue about whether loans are classified as liquid in the SEC's eyes because of the settlement cycle on loans. So if these amendments are adopted as proposed, it would essentially outlaw open-end funds, including ETFs, from having loans in proportions exceeding the 15% limit on less liquid securities. And there are a number of very successful senior loan ETFs out there which have been trading away for over a decade without too many problems. So there's a lot of so at least among the segments of the market that believes in these products, there's been a lot of pushback to at least this proposal, and it hasn't been adopted yet, and there haven't been many signals about whether or not anything is going to happen soon. Just to touch on very briefly on the advisor outsourcing rule. Also, about a year and a half ago, the SEC proposed a rule that would have required advisors to implement oversight policies and procedures for any outsourced functions. And the way the proposed rule would have defined outsourced functions would have picked up index providers for index products, including ETFs. And generally speaking, this is one area where the US regulators look longingly at their European counterparts, because the European regulators do have direct ability to regulate indices. Whereas in the US, there isn't really a regulatory authority that has direct jurisdiction over an index provider's computation of an index. The SEC regulates funds' use of indices, but they don't actually have a way to reach index providers directly. So one of the ways to interpret this proposed rule was that it would essentially have given the SEC the ability to indirectly regulate index providers just via the SEC's oversight of fund advisors. However, in recent months, this proposal, the SEC released its updated regulatory flexibility agenda, and this particular proposal was on the long-term list, which usually is code for something that's not happening soon.
All right, thank you. I think we're getting thrown off stage now. But appreciate everyone's time. Thank you very much. Very informative.